Good morning, class.
Good morning, sir.
Yeah, hope you are well today.
Yes, sir. Yeah.
Okay, so let's get started. Last week we continued our conversation, discussions on the thought of trespass to land, and we were able to cover at least 80% of the course contents with respect to the topic. Now, today, without wasting our time, we'll go straight to the outstanding subtopic, which is on trespass to land by air. Then from there, we'll move to defenses and remedies. So, and please, for those that want to ask questions, let's try and make our questions very brief and also get set for the questions, because one is 2 minutes or 1 minute to 11. I have to end the class so I can enter housing law. I don't like the way my class is dragging beyond time. Okay, so now let me see if I can share my screen. And like I promised the last time, I'm still working on this slide. I'll be so busy, so I can't develop it more than this. So hopefully before, let your class rep remind me, latest by Friday, I mean tomorrow or okay, later by Saturday, so I can send this to your class. Now, okay. Can you see the slide now?
Yes, sir.
Yes.
Okay. So, let's look at from the for we stop at continued trespass. Okay, sorry, we stop at examples of trespass to land, and so let's look at trespass to the airspace above land. So just briefly, they will move to defenses and the remedies. Now, the expression could use S solu, it use S square ad column, it square ad inference is the basic maxim of law that talks about trespass above and below the surface of land. So, as a general rule, entry below the surface of the land or entry on the airspace, if it takes place within the area of ordinary use, is trespass. That is as a general rule. So whether it is within the ordinary use, the area of ordinary use, or above the area of ordinary use, it is still trespass by way of general rule. So, and that maxim simply means who owns or possesses the surface of land also owns or possesses everything above it to the surface, to the heavens, and also everything below it to the entire center of the earth. So now, if you look at the case of a corbett and an eel, like I said, I'm just going to give you that case as well. If you look at the case of a corbett and eel, so that proposition of law was highlighted to the fact that any invasion of the ground beneath the surface at however great a depth, and any invasion of the airspace above at however great a height, will constitute a trespass to the possessor of the surface land. So, and that has been the principle, the general principle of law as it relates to trespass to the airspace or beneath the land. So, having said that, we are going to consider a few cases that will help us to drive home our points. And so on that note, let's look at the massing begin and adopts and look at the two or three cases to make our points explicit. Now, as I said, whoever owns or possesses the land will be held to own or possess everything up to the heavens above the land and everything below the land to the center of the earth. So, however, this maxim cannot be taken literally both for the airspace and beneath the earth. So, in other words, we are talking of the exception now to that general principle. So, let's look at the case of Kessin and Imperial Tobacco Limited. Okay, let's look at the case of Kessin and Imperial Tobacco Limited. Now, where a signboard on the adjacent premises protruded a few feet above the plaintiff's premises. Now, it was also held to be what? To be trespass. And so, this is based on the general principle of the tort of trespass by way of the airspace. So, look at the case again. Kessin and Imperial Tobacco Limited. I'm sorry, Professor. My lead professor is asking a question about the class. So let me quickly respond to Professor Adekile. You just give me 1 second. Okay, so Paul was saying that I just supposed to be the one that will take the class today, but I now replied that by the timetable that I have, my class is supposed to end today on this topic. So we are good to go. Now, like I was saying, I said the case of Kessin and Imperial Tobacco Limited. So where a signboard on the adjacent premises protruded a few feet above the plaintiff's premises, it was held to be trespass. Now, you contrast this particular case with the case of Wawolati Limited and Costain Limited. Now, please, class, note this. When you see my notes and I say contrast this, so what I should point to you is that you need to be able to distinguish between the two cases, okay, or the cases that you have that phrase, contrast this, contrast that. So now in Wawolati Limited and Costain Limited, where also a crane of defendants swung over the plaintiff's roof at a distance of 50 feet, it was held to be also trespass. So when you look at these two cases, the holding may appear similar, but they are not actually the same. But we'll get that as we go. Now, having said that, let's look at the case of Kesin and Imperial Tobacco Limited that I just mentioned earlier. Now, an advertisement signboard fixed by the defendant company on an adjacent premises projected into the plaintiff's airspace a few feet signboard into a space. The court held that was trespass. Now, the invasion of the airspace by the advertising sign was a trespass. Now, the plaintiff was entitled to an injunction for its removal, even though the act complaint of resulted in no harm. Now, we mentioned that the thought of trespass to land is actionable per se. That we don't need to prove any special damage at all. So it is not a case of the defendants trying to justify that after all, there was no injury or there was no pecuniary gain to him, or there was harm done to the claimant. So, and that was why I repeated that particular case here as well. Now, having said that, let's also look at the case of Bastin and the Sky Views and General Limited. Now, the defendant company was taking aerial photographs. So this is the case that I also want you to contrast with the earlier one. Now, the defendant company was taking aerial photographs from about 650 feet in the air, crossing the plaintiff's land in the air. In order to do so, the plaintiff claimed damages for trespass to his airspace and for invasion of his privacy. Government J held that the defendants were not liable, and this because an owner of common law had rights. Hello, who is that person now? An owner acts.
That I put in short yesterday. Let's blame. Let's label. That is not good. It's not good.
Brother, please mute your mic.
Class chair, please. When the person is ready, let me know.
So I think already. So no one speak it.
Okay. So an owner at common law had right above his land to such heights in the sky as was reasonably necessary. So the word reasonably necessary for the ordinary use and enjoyment of the land is very important here. Now, the plane in this case, which flew at a height of 630 feet, did not interfere with reasonable use of the land. The reason being that it was too high to be trespassing. So we are going to also look at the reason for this decision. What we consider Section 40 of the Civil Aviation Act of UK. So now, what is most important here is the reasonableness of the ordinary use and enjoyment of the land. So the act of the defendants must be seen to be reasonable before it can be exculpated from liability. So now, having said that, let's go to Section 40 and Section 9 of equivalent in Nigerian's case. Now, in the case of Bastin that I just mentioned now, it was held that the maximum does not apply in a situation in which the defendant's aircraft flew several hundred feet above the plaintiff's roof. The court proceeded that the maximum only extends to the point of reasonable use of airspace above the land. Now, reasonable use of airspace above the land. So, that point must be emphasized, reasonable use. Now, what is reasonable, of course, in circumstance will be determined by the courts and based on the facts before the court. Now, Section 40 of the English Civil Aviation Act was interpreted to obviate the defendants of liability. So, and that section also has the we have the equivalent in Section 9 of the Civil Aviation Act. So, and by the provision of that particular section, it simply state that no action shall lie in respect of trespass or nuisance by reason of only of all of ordinary incidents or the flight of an aircraft over the property at a height above the ground to which is reasonable. So this is having regards to wind, weather, and all the circumstance of the case. Now, so that is the requirement of the provision of Section 9 of the Civil Aviation Act, and also the requirement of Section 40 of the English Civil Aviation Act. So, and there are also exceptions to this. By the provision in this subsection, if the damage is caused to any person or property by an aircraft in flight, taking off or landing, or as a result of a person or thing falling from such aircraft, then the owner of the craft will be liable for damage without proof of negligence or retention. So that law only talks about the movement of the flights. Okay, so whatever damage that aircraft has caused to the person or to the property will not exculpate the defendant from liability. So that's an exception to that provision of the law. So by the way of this section, if the damage is caused to any person or property by an aircraft in flight, taking off or landing, or as a result of a person or thing falling from such aircraft, then the owner of the craft will be liable for the damage without proof of negligence. So and like I also mentioned that you can see the battery supply. But that would have been a trespass if the aircraft or anything from it had fallen to the ground, and that's what the court said. So, the act of flying or the act of taking off, if it causes injury to the nearby or the adjacent properties, then the aircraft owner will be liable for the injury caused to them. So now, for our discussion on the highway trespass, which I mentioned last week, you can look at the case of Hickman and Macy. Look at Smith and Giddy. Contrast the case of Smith and Giddy with Director of the Public Prosecution and Jones. Then you can also read further Harrison and Duke of Rutland, Fadugia and the GWR. So I'm going to make these cases available to you as you go. Now, the principle as enunciated above, can we say the same principle applies to the entry below the surface of land? Hello, class, can you hear me? Class,
yes, sir, we can hear you.
Okay. I made some unpleasant sound. That's what I'm asking. So, as regards entry below the surface of land, a Fleming's of the view that,
Please mute your mic.
is of the view that the rule applicable to the invasion of airspace should also be applicable. And this means that trespass will apply only within the area which could be reasonably used by the occupier. So now there's no strict provision as to the entry below the surface of the land, but the literature abound that the rule applicable to the invasion of airspace should also be applicable. And why this is a bit unfirmly confirmed is because of the depth of cases in respect of the entry below the surface of the land. So, but as we're going to see the case of Cox and Glue, Bully and Co. Mining versus Osborne, Bocado SA and the Star Energy UK Onshore Limited. You look at these cases also, they were explained better on the trespass above the land and also below the land. So, having said that, you especially the case of Abuli and Co. Mining versus Osborne. So that case is very important, and that was where the defendant tunneled under land in the possession of the plaintiff's land for the purpose of exploiting a co-steam. So, and also where many rights have been granted by the owner of the service, then of course there will of course be no trespass where the grantee exercises those rights in conformity with the agreement. So it's only when the defendant goes beyond the stipulations in the agreement of use that the claimant can lawfully maintain an action in trespass to land against the defendant. So we are going to consider this as well under defenses. Okay, so that's all about the trespass by entry below the service and also above the surface of land. So you can read further Julius and Wilfrid. You can read further also ISSA Malemi. Some of you are parading ISSA Malemi, so it's also good. So you can also reach your Alupo that you have as your Bible. So then there's a particular book that's not really available. It's written by FC Nwoke. So you can lay your hand on that book. You can also read through. So there are many things you can read in thoughts, and what really matters is that ensure that you are reading text that will simplify things for you, not the one that will compound issues for you. And again, let our class discussion guide your reading as we go on in this journey. Now, so let's now move to defenses so that we can finish early today. Now, for what is certain, or what is constant in life, and it has to do with defenses. Now, the fact that it appears someone has unassailable claims does not mean that the other does not have anything to say when is confronted with some allegations. And that is where the concept of fair hearing comes in. So it is left for the defendant to decide as to whether to defend a claim of trespass to land leveled against him, or he simply wants to walk away and say, well, I'm not going to defend the suit. And so that now gives the entire body of proof to the claimant to prove his case before the court. It's not as a matter of rights that when you file the case before the court, then automatically the court will give judgment, even when the case is not defended. So the onus of proof now lies on the claimant to show to the court that he is entitled to the release being sought in his writ. So if the defendant elects to defend the case of trespass to land, then there are some defenses that his lawyer will look at with a view to defending him accurately and effectively before the court. So the following defenses are available to a person who is sued for trespass to land, and where he establishes any or of a combination of them, he will completely be exonerated from liability from the acts of purported trespass. Now, so one of such defenses that's readily available to the defendant is license. I'm sure some of you have been reading will have find this in a textbook. Now, without going through in detail into the types of licenses that you have, what is certain is that a license can be construed as the consent given to another to enter upon the land. Okay, and once you are given that approval or the consent to enter upon the land, then a claim of trespass against you will fail. Okay, so and this license could be either express, that is, the owner give direct permission to trespass to remain upon the land in question, or it could be implied. In other words, the level of lashes and acquiescence, as we're going to see as we go on. So in other words, by the action of the claimant, the defendant thinks that he has right over that land. So I'm sure you did the implied express types of contract in your contract class. Then you have the one that we call contractual. Okay, so this occurs in certain way in which entry into the land as a result of contractual obligations. E.g., a plumber is contracted to carry out some repairs on the land. So, and so far as he was not done with the repair, he could not be cited for trespass to land. And so on and so forth, and other similar artisan work. So now, the second one is the right to resume possession. Now, before I go to the right to resume possession, you can also look at the case of Akari and Garam under the license. The case of Akari and Garam. So Akari is spelled K-A-R-I, then versus Garam. So and what I simply say is that the license does not pass any interest in property and cannot be used as a basis for trespass. So it was held that a bare simple license is revocable. So by the licensor at any time, and such a person has no remedy. In other words, once your license is revoked, then you cannot claim that you have initial license to enter the premises. So the moment the licensor revoke the license, your stay in the property is no longer welcome. So you cannot use that one as a defense that you have a license initially. Okay, so now the second one that interests me to also mention is the right to resume possession. Now, this is a good defense to an action for trespass. So when the defendant has the right to resume a possession and does reasonable act for the purpose of resuming that possession, even to the detriment of the person in possession, then so in default of the possession, they cannot be held liable for trespass. Now you can look at the case of Akodu and Omidiji. So that case was reported under NLR. So in that case, the plaintiff as the auditor failed to perform certain ceremonies related to his stool. So consequently, upon which the defendant was elected to replace him. Now, the defendant through his agents broke into the what we call their palace, that is the Iga residence, where the plaintiff was living. That is the person that was elected after the initial appointment of Oloto. So in an action for trespass, it was held that the defendant has a right to enter the IGA, and as such, no trespass has been committed. So because naturally that title belonged to him. Okay, having been elected through a certain process. What he did not do was to subject himself to certain ceremonies. Okay, we does not take the fact that he has been duly appointed as a lot. So now for the third one, you look at the justification by law. Of course, this is one that a person has been asked question over the years. Oh, sorry. Now, for justification, for the defense of justification, you pay attention to the act which will otherwise amount to trespass to land. This will not constitute trespass because of some justification provided by law. And I mentioned to you earlier, I think last week, about the persons who are in lawful authority, the police who are executing certain enforcement processes on behalf of the state. Then you also have other law enforcement agencies and you have who are trying to effect arrest and carry out their duties according to law. Then you have the bailiffs of the courts, who serve processes. So they are protected under sheriff and civil process law of respective states. And you have also the National Electric Power Act, now defunct, who empowers the NEPA officials to, as a matter of rights, enter your property and carry out their legitimate duties. So, and we also spoke about the exception to this a particular act. Okay, and I said the fact that their act is unlawful in the process, that does not make the evidence they have gotten to be illegal. So, now a person who enters a land pursuant to some rights under the statute, under the law, or other legal instruments cannot be a trespasser, provided that the conditions stipulated in the enabling instrument are strictly adhered to. So, for example, like I mentioned, a plaintiff under the sheriff and process law who enters into premises for purpose of serving court processes on the person residing therein cannot be liable for trespass. Also, the staffers of the authority of the National Electric Power Authority Act cannot also be liable in trespass for the purpose of reading the meter or also ancillary matters relating to that. So in this circumstance, the act of entry cannot amount to actionable trespass. So this is by way of justification that we say lawful justification. And don't forget our definition of the trespass to land. Okay, entry without lawful justification. So then again, another point to note in this gen of defense is abatement of nuisance. Abatement of nuisance. Now, a defendant who enters a land in the occupation of the plaintiff for the purpose of putting to an end an act of nuisance emanating from there has a very good defense to an action in trespass. So, for example, in the case of Obasa and Sarua, in this case, the plaintiff widened a highway with the consent of the defendants. Okay, so but he spent money on it and placed a gate across the entrance, and thereby collected the tolls from vehicles plying the highway. Now, the act of placing the gates on the highway, of course, we know that constituted a nuisance. You are going to do nuisance second semester. That act constituted a nuisance. Now, this act of placing a gate on the highway constituted a nuisance, which any person affected by it could abate. You know, by way of abate, abate means stop. Okay, could stop. So in an action against the defendant for trespass, the court held that the action failed as the entry of the defendant was for the purpose of removing the nuisance, abating the nuisance. So to remove the gates. So on that note, he could not have said to have committed a trespass. So then they also look at the lashes and acquiescence. Lashes and acquiescence. That's another defense. So when we say lashes and acquiescence, how many of us have done okay, sorry, you're in 300 level. I presume that you're already in 400 level. How many of us have done or know the meaning of lashes and acquiescence? We'll go on at all. A class chair, you want to help us, so I won't waste our time. A class chair, you want to help us? Lashes. What do you understand by lashes or acquiescence? Or someone that's yes.
I didn't get the word, sir.
What do you okay? Lashes is it displayed now? It's been displayed on the screen. Latches. Under other defenses, I mentioned latches and acquiescence. Can't you see it on the screen? Don't use AI.
Oh, sir, I can see it.
Okay, just
no.
Okay, so just if you understand it, you don't understand it, let's another person. I just want to call you so that they won't know which time any further. Have you heard of what called latches? Okay, then
I haven't, sir.
Okay, can someone else help us? What do you understand by lashes? and acquiescence without looking at any AI or ChatGPT answer?
Failing to assert your right.
Sir? I'm with you.
Failing to assert your right.
Good. Okay. Lashes, ready to assert your right. Then, what about the acquiescence? What about the acquiescence?
And I think
Hello, sir.
acquiescence means, okay, sounds, it means like to kind of agree to something. That's the way it appears to me.
Okay. Well, that's not bad at all. So, by now, lashes and acquiescence can deprive the plaintiff from his right of action for trespass to land. So, when we say lashes means delay in bringing an action. Okay, that's the meaning of lashes, delay in bringing an action. I'm going to give put that definition in the slide I will send to you later. So it means delay in bringing an action, while acquiescence means conduct amounting to a waiver of a right. So now, in foreign level, you're going to be discussing equity, okay, equity principles. So when you hear the word delay defeat equity, I'm sure some of us have heard that word in your legal system. Delay defeat equity. Ill cost to equity must come with clear hand. Now, so that delay defeat equity part is a way of saying lashes. Now, if you suspect that someone has trespassed on your land and you stand by doing nothing to abate the trespass, to stop the trespass, okay, and the person continue in error, thinking that he has a right over your property, and the person continue, and you're looking at him, and the person is able to invest so much of money, the person has invested billions, imagine someone go to Lagoon Funds, okay, and start filling the water. Maybe it took like two plots of land. Oh, sorry, two plot of water space, and start filling it. And the owners are looking at him. They're looking at him. The person finished it. Maybe he thought it's free for all, and the guy was there. Sampling it. Spent almost 1 billion to sample it. And they were looking at him. In fact, they even came there to greet him. How are you? Good morning. Hope the work is going one way. And they play with him. They even bought him water, bought everything. And the person now consulted ADV's water 2 billion on it. And when the person is about to do housewarming, someone now come to him and say, this part you have built is my space. And the person was aware of that particular act when he was building it. So equity will not allow that person, the law will stop him from claiming that space back. So that's what we call lashes. Then acquiescence means waiver. So now it's an equitable doctrine which forbids a person who unnecessarily delays in bringing an action to enforce his rights, and or through his conduct misleads another person into changing his position from bringing an action to enforce his rights. So in this case, the courts always consider not only the delay in bringing an action, but also change of position on the part of another as a result of such delay. That position is that the person has thought that he has now comfortably owned a place, and you suddenly come and say that the property belongs to you. So it has been stated that in the case of forgiving that you did in your legal system, so that if the plaintiff in his conduct has done what may be regarded as equivalent to a waiver, but the other party is in a position in which it will be unreasonable to place him, then the doctrine of lashes and acquiescence will apply. So if money cannot compensate the person who has built in error, then latches and acquiescence will apply to safeguard the interest of that person, that innocent young man who has built on the property in error. So that is one of the defenses to trespass to land. So on latches and acquiescence, I'm going to send some questions to you, Rufai and Elise and all that. But beyond that, there are many conditions that must be considered before the principle of acquiescence can apply. Especially acquiescence can apply. One will be said to have waived his rights. So there are many. I will try and maybe put 2 or 3 of them in your slide as well, so that will get you when you are reading. For example, B was mistaken that the land in which he was building belonged to himself. Okay, and he has expended so much money, and the person who owned that property was standing by, doing nothing. So the court will stop the owner from claiming the land back. So that is also on that. Now, then also we have another defense which is called beta type 2. Beta type 2. Now, for beta type 2, 2 individuals may be claiming ownership or maybe claiming possessory rights over a particular land. Okay, so it is the law that the person with the beta type 2 will have the right in law. So what that simply means that if someone who is a trespasser, believing that he owns the property, and sue someone who has better title than him for trespass to land, he sued the person that the person trespassed on his land, and the person he sued was able to prove before the court that he has a better title to that portion of land, then the court will not hold in favor of the claimant. So several rights may coexist on the same piece of land. So anyone having better title is therefore presumed to be owner. For example, where a defendant is sued for trespass and puts better title as against the plaintiff, he cannot be liable for trespass, because in the first place, the person who sued him for trespass did not have a better title than him. So you can look at the case of Adeyemi Lawasin and Ayodele Ajibulu. Okay, so which I'm also going to send later as well. So in that case, it was said that where 2 persons claim to be in possession of land, to succeed in trespass, the plaintiff must show better title to the land. So now let's consider limitation of action. Okay, so limitation of action can also is also one of the defenses to trespass to land. So it's related to latches and acquiescence that we mentioned earlier. Okay, so now by limitation of action, it is the statute that determines. So statute determines what will amount to limitation of action. Statute regulates the commencement of proceedings in court, and so to that extent, where a statute has given some years or some timeline within which someone who claim to have been or someone who claim that his land has been trespassed upon should bring an action, and the person fails to bring an action within the time stipulated by the law, then the claimant will not be able to maintain will not be able to have any remedy in the court of law, despite the fact that it is obvious that the person's land was trespassed on. Okay, so now the special note should be taken of issues concerning land under the limitation laws or act, as the case may be. Now, most states have their own limitation laws. Okay, while the federal has a limitation act. So, for example, the provision of section 7(4) of the Limitation Act provide that the time limit for institution of an action founded on torts is 6 years. I'm sure you were also taught in your law of contracts the limitation law, the limitation time to bring an action in contract. So it's like 6 years. So that the idea is that so that the person who has trespassed on your land will not be able to continually trespass on your land if you bring an action within that period of time that the law stipulated. Otherwise, your right to litigation, your right to claim before the court will be foreclosed by the Limitation Act. So that's all. But however, if the act of trespass is brought together with action for recovery of land, because majorly land matters are peculiar in nature. Why the general law of tort says you need to bring an action for trespass in 6 years. For the land action, you need to bring an action within 12 years. So the law says 12 years for individual. For example, if you claim that your land has been trespassed upon, okay, the law says you have to bring an action against the trespasser within 12 years. If you don't bring an action within 12 years, then your rights can be foreclosed by the court of law. So, but that is in the case of individual. But in respect of the states, if a state is the one complaining of a trespass, if a state is the one complaining of trespass to land, then the law say the states can bring an action within 20 years. So while the state is 20 years, individual is 12 years. So what that simply means that the state can bring an action 18 years after trespass has been done on a land. 19 years can bring it, but for individual, the law say must be within 12 years. So you can see it's on the screen. 12, I said 12, 20, and 6 years rules apply under limitation of action. Now, so having said that, let's now consider the remedies. Now we have general remedies and we have specific remedies. For general remedies, these are the remedies that you are familiar with. I'm sure you have been taught in your introductory class or classes. So, of course, for any action in tort, we have been told, or personally, I told you when we had our first introduction at the beginning of the semester, that damages is usually the remedy available in tort action. So this is monetary compensation charged against the trespasser to be paid to the owner of the land. So this could be nominal or could be general. Of course, I don't to be telling you the difference between nominal and the general. So then you have what we call an injunction. So this is where the owner of the land seeks an order from the court to order the trespasser to leave the land being trespassed upon. So you have discovered that someone has trespassed on your land, and you want to stop that trespass. So you approach the court for injunction, restraining him from continuing trespass on your land. Then, of course, you have an action for recovery of land. You want to possess your land back. Then this normally occurs in land dispute situations. So in this scenario, the owner of the land will bring an action against trespasser, and we have to prove that the land belongs to him. So let's consider specific remedies in detail. Now, the first is re-entry and defense of property. The first is re-entry and the defense of property. Class, I hope you are following me. Is that the class is a bit calm today? Class, are you following me?
Yes, sir.
Yes, sir.
All right. So you have re-entry and defense of property. So for the entry and defense of property, you have been told under your trespass to person that one of the defenses to trespass to persons action is defense of property, okay, of your person and your property. So now a person will have a right to entry upon a land if he has right of way. A right of way is the right a person has to go through another person's land in order to get to his own destination. So it will be given by either the owner a public right of way under common law or a right of way under statutes. Now, also in your foreign level, you're going to be talking of easements. You're going to be talking about profit appender. Then you're going to be talking about right of way. Now, so the law allows individual to give individual the right of entry at the appropriate period of time. And so for the right of entry, the court has stated in the case of Hemmings and the Stokes Pages Golf Club. Hemmings and the Stokes Pages Golf Club. Now, this right of way operates to enable a person who is entitled to possession to enter the land or enter the premises, provided the entry is peaceful or reasonable force, is used for that purpose. So it's in form of self-help. You push the person from your land once the person is not injured, or you use minimal force to take the person away from your land. So that's because you have the right to entry. Now, the challenge with this kind of remedy is that it can bring, or it can cause breach of public peace, because when two persons are struggling over a land, then the right a person to that land can be injured along the line, or even the aggressor, the trespasser, can also be injured along the line, and so that could cause the breach of public peace. So this remedy is least used or rarely used. So, and it is not the best remedy, since it makes the environment more susceptible to use more force than necessary, and thereby make him liable for damages. So that can make even the person who's claiming the right to be liable in damages. So you have seen landlords going to court, are going to prison. Some landlords are not going to prison because when the tenancy expire, other than issue quick notices and commence the eviction procedure in court, they will just they will remove the roof of the tenant. They will lock the gates against the tenant and all that. So this remedy was common under common law, but because of the adverse effect of it, what it will portend, it is better to jettison this remedy and look for another remedy. Now, so also you have what is called ejectments. I think I mentioned that, yes, ejection of the trespasser and his properties by self-help. So this also is related to the first one. It's related to the reentry that we just explained. But in the case of ejection, a person who has been dispossessed of land, so he has been dispossessed of his land, he has been left out of his land, may bring an action for ejectments where he can establish an immediate right of possession. So the plaintiff is entitled to succeed on the strength of his own case and not on the weakness of the defendant. So he must be able to prove before the court that he was right, he was wrongfully dispossessed of his land. So all that needed to do to show that he is in possession the plaintiff will have the body of proving that he has a better title. So all the defenses, all the remedies are a bit interwoven. So now, what could bring an action for ejectment? Ejectment could be the acts that may render a person liable for ejectment will include non-payment of rents. I discussed this in one of my articles, which I gave to foreign level students now for their housing law. Now, non-payment of rents can be a ground for ejectment. Doing acts that threaten the safety of the premises can also be a ground for ejectment. Now, if you are a smoker or you are a smoker of M or hard drugs, okay, and this affects the safety of your co-neighbors, the owner or the possessor, that is the person who has a right to immediate possession, can actually eject you through the court process. So then also occupiers who renders quiet occupation impossible can also be evicted from a property. That is, you are blocking the right of way of your co-tenants. You are parking in front of someone's door, and so on and so forth. That can be a ground for ejectment. So there are a lot of reasons why an action for ejectment can be brought by the claimants, okay, in order to rescue possession from the defendants. Okay. Now, also, there's what we call claim of main profits. Of course, you have distress of seizure of property in lieu of payment of damages. So I'm going to send a short note on this for proper understanding. Now, there's what we call main profits. Okay, claim for main profits, not mere profit. Main profits. Okay, so what some people call mercenary profits, but it's main profits. Now, as someone asked one of the brilliant questions here in class, was it last week, about whether the position will be the same for a tenant who owes over, who free to leave the premises after his rent has expired, whether the person can also be called a trespasser. And so that, and I said that the tenancy law of various states will not define such a person as a trespasser, because by law is a statutory tenant. Is not a trespasser, as it cannot be seen as trespasser as defined under our general definition of trespasser. But because the law gives you some kind of comfort, the law gives some of protections against being treated as such. So what the owner can do, or the claimant can do, for someone who held on to tenanted property and has refused to leave, even upon being served with notice, is to claim in court what we call main profits. So where the plaintiff suffered damages for being out of possession of land, where he is entitled to such possession, an action lies for damages. Now that damage is called main profits. Now this includes damage for the profits taken by the defendant during his occupation. So I usually call main profits. Now, so main profit has been defined in the case of Ayinke and Lawa. So see the case of Ayinke and Lawa for further discussion. Now, in that case, the court held that the rent and profits which a tenant who holds over after the lawful termination of or expiration of the tenancy, or a trespasser, or might have received during his occupation of the land or premises in issue, and which he is liable to pay as a possession to the person entitled to possession of such land or premises is called mean profits. So, mean profit also is another name used for damages for use and occupation, okay, by the definition of statutes, okay, but by landlord and tenants experts, mean profit is not the same as damages for use and occupation. But for the sake of the definitions of the law, mean profit is another name for damages for trespass arising from the particular relationship of landlord and tenants. So now, and the good thing about this mean profit is that is calculated based on the fair and real or actual value of the property in occupation, of this property in occupation. Now, if your rent was 1 million naira last year, and you are being served with notice to leave, to quit, and another has comments against you in court, you refuse to leave the premises, the court is going to give judgments based on the current, calculate mean profit based on the current market value of the property around the area. So, in other words, if it's not 2 million naira this year, the court will award mean profits in the sum of 2 million naira as against 1 million naira of your initial entry rent. So that is what that is all about. Then, of course, you have also putting up a notice warning to tell trespasser to keep off. So as one of the remedy, you can also put in your house, you can also put dogs are in this house, trespasser keep off. There are a lot of signs you can put in your corridor to inform people that they are not welcome in your premises. So that is all for now about trespass to land. So what we have done so far is to cover the field as contain our learning outcomes, which is that students will be able to hold firmly their trespass to land is actually per se, understand the basic element of the thought of trespass to land, understand the meaning of trespass to land, bold and coming, examine the various forms of trespass to land, discuss the various defenses of trespass to land, and identify various examples of trespass to land. Then with the remedies, yes, remedy, defenses and remedies. So now I think on that note, we are done. Question time. Please, we have 27 minutes to go, and I must end the class. I think a minute before 11, so I can enter housing class. Okay, Bolu, you are the first to raise up your hand. Any question?
Yes, sir. I have 2 questions to ask, sir.
Please go ahead.
First, under abatement of nuisance first. So I have a scenario in mind. Let's say based on the question that Gabriel asked, a scenario in mind based on like that other question that Gabriel asked of a tree in a person's house that he said is nuisance. Let's say that tree has grown so large and then the leaves are entering into my compound. But inside like the compound where the tree is growing, it's like unoccupied or it has not been developed. It's just with branches and with trees and grass trees, but I know the owner. And then I walk into the land, I cut the tree. Will that fall under a defense of abatement of nuisance?
Now, the question is that is the land and I jump property to you or your own personal land? I didn't get that initial.
It's not personal land. It's not personal land, sir. It's an adjoining property.
Okay. So yes, the branches were disturbing you. Is that not? The branches of the tree.
Sir.
Yeah, yes. That can form part of the abatement of of nuisance because it is called abatement of nuisance because of the fact that the thing protruded to your land. On that note, that may be a good defense in court. What you just mentioned now happened to my clients around Magodo. Okay, and she was in the our neighbor had the habit of planting these trees that could enhance the aesthetic nature of the neighbor's house or property. But the thing was protruded to our own and what he did was to trim it from our end. So when you are trimming from your own end, there's no way you're not laying on the neighbor's land. So on that note, it depends on abatements can avail you. Yes, Ushita.
Okay. Sorry, sir, I have two questions. Can I ask the second one?
Oh, who is that? Okay, who is that person? Is that Bolu?
Bolu, sir. Bolu.
Okay, so before please, other can also. I have 5 persons listening.
Okay.
So I want to take all of you, please. Before, yeah, go ahead.
Okay, sir, I'll be very fast. This one now is a land/tenancy matter. So now a tenant or a landlord drops blocks on his land. Maybe he wanted to continue building, developing, build another property on the land, but there's an existing property where a tenant is staying in. And then without the permission or the knowledge of the landlord, the tenant takes the block and starts building on the landlord's land. Is that trespass, or is there a defense that the landlord can claim as maybe you are trespassing on my land, I did not give you permission and all that stuff?
Now, you know that the law, tenancy law, frown against developing landlord's property without his consent. So the consent must be in writing. That is the law. The law says any improvements that will warrant the claim of maybe compensations for the improvement made on the land must be with the consent of the landlord. So now, for the sake of trespass, if the development you are carrying out is within your own apartment, within your apartment, that will not amount to trespass. Hello, please give me that will not amount to trespass. However, landlord can maintain another action for whether maybe for alteration and all that, but not for trespassing, because you are in possession at that time. But if the tenant moves to appurtenances, that is, it moves to other territory of the landlord, which was not part of what was contained in the tenancy agreement, then there will be a trespass. There will be a trespass. So, and that's why I always tell you that fact of the case will determine whether an action is amount to trespass or not. And the safest way to find out whether an act is trespass to land or not is for you to understand the elements of trespass to land, and also look at all the examples I've given and see whether some of the examples that we have brought out in this class have semblance with what we have said in this class. And the cases authority, there are many cases. Because I'm limited with time. How many cases that I can be talking even offhand, they give you offhand and give you the fact and another. But beyond that, I also recommend that you have to read widely. That's really why I understand that you don't really have most time, but you have to create time out of no time. You are going for holidays now. For me, holidays will be the best way for you to eat, to read. Okay, and do not consume so much food during this holiday. Of course, there will be temptation to eat so much because you want to visit your friend and all that. But that does not mean that you should not create time to read your book. So read cases. Cases will assist you a lot. And I'm recommending many textbooks for you. I'm not saying you should go and read all the textbooks line by line, but at least pick the salient point in the book and also move on. So Daniel, You have the floor. Play the first.
Yes, sir. Thank you, sir. So what
Yeah.
about those houses that on their fence they will write post no bill? So someone that now posts like let me say a flyer on that fence, is the person
Yes.
committing a trespass to land? That's my question, sir.
I didn't get that question where. I didn't get the question where.
Okay, sir. Let me come again. You know that on some fences that they will write post no bill. Do you get,
Yes.
sir?
Yes.
So someone that now posts a flyer on
Yes.
that fence that they wrote post no bill, is it a trespass to land?
Definitely it's a trespass to land. Why are you bringing out the question? Why are you bringing out a part of the question that I want to give you? Well, it is indeed a trespass to land. Yes, because that is even whether there's a signpost or notice to say that the post no be, if you invade into private property, is a trespass to land. So, okay, if you invade into another man's property, that is a trespass to land. Whether they put post no be, if I put post no be, it's just to even help you. Now, please don't come near here. Okay, so but for those that normally post anywhere, if they are caught, they can be sued in trespass. Okay, so and I'm aware some of you that what you use to feed your family. You just go to you help some event planners to take the flyers and start posting everywhere. It is torture action. Okay, goodness, it's good success. Udo.
Okay, good morning, sir.
Okay, Daniel, am I done with you, Daniel? Am I done? Your hand is still. Daniel, your
Yes,
hand
sir.
is okay. All right. Okay. So success.
Okay, sir. Sir, my
Yeah.
question is that is it possible that ejection is illegal, although you mentioned it as one of the defenses?
No, I didn't get that ejection is illegal. No, I'm not saying I'm not saying ejection is illegal. I'm not saying ejection is illegal. What I'm saying is that that self-help. I said self-help may self-help should be really used because of the implications. But that ejection is the best way to evict a tenant from the premises. You know, what that simply means that you file an action against the person in court. Okay, if at times your claim is clearly set out in your relief. I mean your claim. What you want the court to do for you. You can do that by way of ejection. But the one that I said you need to be wary of is the re-entry. Re-entry is like a form of self-help. You don't need to get court order. Because it's your property, you can remove those trespass persons from your land. But in attempt to remove them from your property, they are now struggling with you, they're not fighting you. Okay, so that's why I said because of the implications, and I mentioned the case of Emmings and the Stokes Hodges Golf Club. Because of time, I was unable to narrate what happened in that case. But okay, let me just say this, that in that case, a tenant of a cottage owned by the defendants refused to quit after the expiration of a notice given to him. So the defendant now thereupon entered the cottage and removed the plaintiff and his furniture. So he removed the furniture, removed the plaintiff from the premises, using no more force than was necessary. So there was no force. There was just a commensurate, a medium force that I used. So in an action for assault, battery, trespass to land, and so on and so forth, the defendant were held not liable because they re-entered their land, and in so doing, use no more force than was necessary. Now, the question now is, how do you determine the force that was necessary, the force that was not necessary? And I said it's better that you don't use this method, because this method can expose you to litigation. And I said the cases are reported. Just Google online after this class. Google online. Landlords charged to courts for evicting the tenant illegally. You will see many cases that will come up. Stories. Imagine your own property. The court sent you to prison because of your, or because you did not do the right thing, or in an attempt to remove the tenant from the property, and there were issues. So, and I give an example that where a locked window or door was broken, you break the door of a tenant because he has to pay his rent, you can be charged for criminal offense. Thank God you are doing criminal law, so you can be charged for criminal offense. Or you broke his window, or you remove his roof. So that was what the point that made me to explain that as against ejectments. Okay. So Omalabake Joshua. You are the next.
Good morning.
All right. Good morning.
So, yes, sir. In a scenario where I have a plantain tree in my compound, and then when it brings out plantain, like the fruit started protruding into my neighbor's compound. And so my neighbor now cut the plantain. But however, she did not cut it when the plantain was still very when it was not mature. So she cut it at the point the plantain was already matured, like was already matured for even consumption. So in that case, will the abatement
I can't hear you again, no. Class, can you hear Labake? I can't hear again. Class.
So I think I wanted to ask if the defense of the abatement of nuisance would have held that neighbor.
Yes, I got a question. I'll just ask you whether you heard that very well. So you know, it's still the same way I answer Bolu, but you cannot go. Abatement will not help you if you go to the person's land to go and cut the tree, or to go and cut whether the root. Now, what you can do, I've told you what you can do. If the thing protrude to your side, you can cut it from your side. You can cut it. You can cut it from your. You can cut from your end. You can cut it from your end. And so, in trying to cut it, that can also, you know, it will be a trespass, because you are going to lean on this person's wall, or you are going to enter the person's land by a bit of margin. So, but go to person's compound to go and cut the person's plantain. That will land into big trouble, and that will be a trespass. Okay, but abatement in this case show that if you do that reasonably, in a way that it does not really interfere with the ownership, the possession right of another person, then you have a legitimate remedy in the court of law. I'm going to send you I think 2 or 3 cases. When you read these cases, you will understand better this principle because of my time. So Ochita, we have the floor. Before Ochita, we have the floor.
Good morning, sir.
Morning. Go ahead.
Hello, sir.
I can hear you clearly. Go ahead.
Can you hear me, sir?
I can hear you now. Go ahead.
Hello, sir.
Class, can you hear me?
Hello.
We can hear you, sir.
We can hear you.
Ochita, your network is not good. I can hear you now. So go ahead.
All right, sir. My question is on limitation of action. You made mention of 12 years for an individual, 20 years for government, and 6 years. I don't know. And my question is, what of a community that owns a land and somebody is trespassing on it? Is there any time limit for them to come up with an action?
Yes. they will be seen as individual.
Okay.
They will be seen as individual. You know, only the state is we. Only the state is we. So a community will be seen as an individual for that purpose. So they have to quickly bring an action. You know, in land law, you'll be taught when you are discussing the concept of adverse possession, you'll be taught very well this principle. There's what we call right of prescription under land law. Right of prescription under land law. So you also be taught. Okay, so but for now, just to say that for the action, for the action in trespass, the law say bring an action within 12 years, bring an action within 20 years, if it is the state. Currently, I'm having a case in court that I'm handling a case for a client in court, and that has to do with trespass. Okay, trespass. And those that trespass are being on the property from time immemorial. I think they've been there for 35 years or thereabout before my client suddenly woke up. And we're in court. And I'm ideally under the exceptions under the law. There are also exceptions to limitation law. But for now, because we are just these thoughts, let's not go into other issues so that we not compound our discussion. Finally, let me hear Stephen. Stephen.
Thank you, sir.
Yes.
Good morning, sir.
Yes. Good morning.
Yeah, I have two questions. So the first one, so I want to know if permission can be implied, maybe with respect to enter a land, or must it always be explicitly granted before it can be used? Permission, can it be implied? Yes, this person, maybe from certain conduct, so that the owner of this land has granted me the permission to either enter the land.
I didn't get that part where I didn't get it where you said someone. Are you talking about license? You're talking about license?
Yes, sir.
Okay, so you are saying that can you recap now? I didn't get that part.
I want to know if permission can be implied, so as to a given property or land, or must it always be explicitly stated that yes, you have the permission to do this?
Okay, no. You know, I've just mentioned now to you that part of the discussion when I started on this was that I said lessons could be expressed, could be implied. So, and I refer you to your thoughts. I'm not to get to that. I refer to your thoughts. To your contract. Okay, to drive home my point that by way of, and that also takes me to lashes and acquisitions. If you are giving license, express one shows that it's clear. You know, when we say something is express, what does that mean? It means the terms there are clearly stated. So it could be oral, it could be in writing. That's express. But for the implied one, so by your action, that can be implied. Let's say, for example, an aboki man or someone in your security guard. Your security guard comes to your apartment where you park or come to your garage where you park your car and start washing your car. That, for example, I start washing your car and you didn't say anything. The following day, you did the same thing. The third day, you did the same thing. Fourth day, almost same. So I kept on washing your car. Then one day, you now said he's trespassing on your garage. So that's an express permit, so an implied permission. So and that's why the say he might not directly invite the trespasser to the land, but by his action, he will give consent. So that's a pedestrian way of giving that explanation through the example that I've given. Now, another point is that someone come to your lunch to come and help you repair certain things. And when the person was done, the person entered the property, you didn't challenge the person. He fixed what he wanted to fix, and he left. So, can you sue the person for trespass? Well, have you benefited for what he has done? And when you not complain to him to leave your premises, so you have that's what I said. Acquiescence is like a waiver of you have waived your rights in that regard. So that implied license also relates to acquiescence. So when you waive your rights, you had opportunity to turn the person back. You did not turn the person back, and the person was doing what he was doing to your satisfaction, only for you to now turn around to say that no. So the court will stop you from maintaining an action against the person in the court of law. So I think this is a comfortable way to stop. I will prompt Professor Adekele now that I'm done with your class, so that she can take over from I don't know, maybe from Monday, but see there's only day on Monday, so that means I will tell her to check her diary so she knows where to call me. So class rep, please remind me later on Saturday if you don't receive the slide from me, so that you can also have it. Okay. Class rep, are you here? Okay. So on that note,
yes, sir.
On that note, I wish the class. Oh, Abib, is your hand up? Abib, I don't have time anymore.
Yes, yes, sir. Let me you've already touched on it before. I just want to just make clarification also. It's on the limitation of action, and you already said that you don't want to go into the exceptions of related to that. But my question basically is that in a situation whereby, let's say, the father, the person who owns the land died, and then let's say after 7 years, or let's say after 13 years, that the son now realized that the land actually belongs to his dead father, then wants to bring an action, like, can't there be like an exception to cover that angle? That's the question.
Do you want me to open another discussion on this?
Yeah, that was why I said you already mentioned.
Where that's one of the exceptions to that principle. What you can show by your acts that you did not realize that property has been trespassed on. That can be, and that's why I'm in court to show to the court that my client was not aware of that trespass action. So the court will likely start counting the dates of the trespass to the period, sorry, of your right of action to the time that you discover. But it's a very difficult task, because you have to show by evidence, not by just mere mouth that I just got to know. So it's an exception, but it's a very technical area of law which should be left for partners like us. So very soon you join us as well. Yeah. So all right. So if I remember, I can put some of those exceptions also there. Okay, but I can't learn everything in a class. That's the challenge. So that learn should be taking like a month, but now I have to rush everything because of the time I have. Okay, so I wish you complete of the season, and see you next year by the grace of God, or hear your voice next year by the grace of God.
Thank you, sir.
Bye.
Okay, sir.
Thank you, sir. Happy New Year in advance, sir.
All right, same to you. All right.
Merry
Thank
Xmas,
you,
sir.
sir.
All right. So your class will tell you on when to do the what do you call it, the tips on how to answer law questions. Maybe yes, later. All right.
Thank you, sir.
All right.
We love you, sir.
My love to all of you.
Vamos.